Good afternoon, members. I'd like to call this meeting of the California Board of Accountancy's Legislative Committee to order. Let's start by taking roll. If we could start with Mr. Pomelat, please.
Present.
Present, Deirdre Robinson.
Kathleen Wright.
Carrie Ann Farrell Hines, and so with that, we have a
General
quorum.
Yang.
I'm sorry,
No problem.
I was going too fast.
I snuck in here. General Yang.
Thank you, and Carrie Ann Farrell Hines. So with that, we have a quorum. We have fulfilled our quorum requirements, so we'll move on to agenda item number 1. Let's approve the minutes of the May 18th Legislative Committee meeting.
So moved.
Second.
Thank you. You want to call for the vote, please? Oh, wait, I'm sorry. I have a second. Are there any additional comments or discussion from board members on this agenda item? Any comments from the public? I will now call for the vote.
All right. Carrie Ann Farrell Hines,
Yes.
George Familet,
Yes.
Jen Oyang,
Abstain.
Deirdre Robinson,
Yes.
and Kathleen Wright.
Yes.
And with that, the motion carries. Thank you very much. Moving on to agenda item number 2. It is the California Board of Accountancy 2017 Legislative Tracking Chart. Ms. Movasaki, can you proceed with your
Thank
report,
you.
please?
Good afternoon, Madam Chair and members. Before I begin my presentation, I would like to highlight some key dates remaining in this year's legislative session. The legislature's summer recess begins today and ends August 21st. September 15th is the last day for the legislature to pass bills, and October 15th is the last day for the governor to sign or veto bills. The CBA will have a final opportunity to take or change a position on bills at its September meeting before legislative activity ends this year. Moving on to the agenda, number 2, the purpose of this item is to present the status of legislation being followed by the CBA. There's no action required, and I would like to turn it back to the chair.
Thank you. Are there any member comments on this item? Any comments from the public? Seeing none, the next item on the agenda is number 3. Item number 3 is an update, discussion, and possible action on legislation on which the California Board of Accountancy has taken a position. Ms. Movasaki, can you please begin your presentation with item 3A, AB 703?
Yes, AB 703 would require every board within DCA to grant a fee waiver for application and issuance of an initial license for an applicant who is married to or in a domestic partnership with an active duty member of the armed forces, if the applicant holds a current license in the same profession in another state, district, or territory. This bill failed to pass out of its house of origin by the legislative deadline and is therefore now a 2-year bill. Staff suggests that the LC maintain its support position. No action is needed. I'd like to turn it back to the chair.
Members, the CBA took a support position at our March meeting and issued our letter on April the 5th. Unless there is a desire to change our support position on AB 703, no action is needed at this time. Are there any comments from the board? Any comments from the public? Seeing none, I'd like to move on to item 3B. Ms. Movasaki, please.
Yes. AB 710 would require every board within DCA to meet once every other calendar year in rural California. This is a 2-year bill, and staff suggests the LC maintain its watch position. I'd like to turn it back to the chair.
Thank you. Members, unless there is a desire to change our watch position on AB 710, no action is needed at this time. Any board member comments? Any members for comments from the members of the public? Seeing none, let's move on to item 3C.
Next bill is AB 767, which would create within the Governor's Office of Business and Economic Development, or GoBiz, a business license center to develop and administer computerized master business license system to simplify the process of engaging in business in California. Recent amendments authorize GoBiz and a state agency determined by GoBiz to have a license which is appropriate for inclusion in the master business license system to borrow money from the general fund to support the reasonable costs of integrating into the system. This is a 2-year bill, and staff suggests that LC maintain its watch position. No action is needed, and I'd like to turn it back to the chair.
The CBA took a watch position and issued a letter to express our concerns. So unless there's a desire to change our watch position on AB 767, no action is needed at this time. Do the members have any additional comments on this item? Or members of the public, would you like to comment on this item? Seeing none, moving on to item 3, Ms. Movasaki, AB 912.
Yes, before my presentation, I would like to highlight that earlier today, under the enforcement report, Madam Chair mentioned the value of including relevant enforcement data in CBA position letters. Staff have made a note of this request and will include relevant data as we draft future position letters. Madam Chair, your comment would also apply to the next item, which is 3E.
Thank you.
Now on to AB 912, which would require most state agencies to help a small business comply with all statutes and regulations administered by the state agency in any enforcement action by the state agency. The bill would require state agencies to create a policy as specified that provides for the reduction and, under certain circumstances, waiver of civil penalties for small businesses. This bill is a 2-year bill, and staff suggests that LC maintain its watch position. No action is needed, and I would like to turn it back to the chair.
Members, since the CBA took a watch position at our May meeting and has already issued a letter on June 22nd expressing our concerns, unless there is a desire to change our watch position on AB 912, no action is needed at this time. Are there any additional comments or questions from our members? How about from members of the public? Seeing none, let's move on to item 3E, AB 1005.
This bill requires DCA's non-healing arts boards and bureaus to issue a fix-it ticket with a 30-day cure period before an administrative fine becomes effective for violation of the applicable licensing act or regulation. If the licensee abates the violation within the 30-day period, the licensee would not be responsible for payment of the administrative fine. This bill is a 2-year bill, and staff suggests the LC maintain its supportive amended position. No action is needed, and I would like to turn it back to Madam Chair.
Thank you. We took a support if amended position at our May meeting and issued our letter on June 22nd. So unless there is a desire to change our support if amended position on AB 1005, no action is needed at this time. Are there any member comments on this matter? Any comments from the public? Seeing none, moving on to item 3F, AB 1190.
This bill would require DCA to publish a quarterly update on its website regarding the progress of implementing the third phase of the BREEZE system. The CBA took a support position during its March meeting. At that time, AB 1190 required DCA to submit an annual report to the legislature regarding the implementation of the third phase of the BREEZE project. Since then, the bill was amended to require DCA to publish on its website certain estimated timeframes, status updates, and results and recommendations related to the BREEZE project. Staff were recently contacted by the author's office inquiring if the CBA still had a support position given the recent amendments. Staff suggests that the LC make a motion to maintain its support position and issue a new position letter. I'd like to turn it back to the chair.
So on this item, we took the support position at our March meeting and issued the letter on April 5th. If we wish to maintain a support position on AB 1190 but also comply with the author's office request to update our position letter in light of the June 13th amendments, I would need to have a motion from our members regarding such a matter. But is there any discussion on this from the committee members?
I mean, if your position's not changed, I don't know if you need a motion. But, I mean, it's up to you if you want to do a new motion to reaffirm your position and direct staff to send a letter with new information relative to these recent amendments.
Does anyone have any strong thoughts or feelings on it? Ms. Movasaki, you've been in contact with the author's office, and you did indicate that they did go out of their way to ask that we reissue reaffirm our support of the bill in light of the amendments. Given that they did ask us to, I think it would be appropriate for us to have some discussion about it.
And also, we indicated that staff cannot speak on behalf of the board members, so it would be beneficial to have an updated letter in
Thank
that
you.
light.
Then I have no problem with updating the letter, if that helps.
And I think I hear that as a motion.
Oh, yes, did you need a motion? I move that we affirm or update with an affirmed letter, a letter of affirmation.
So you're still in support of this bill, because right now, it used to be an annual report to the legislature. This one is just going to be posting on the website quarterly and monthly, correct? Updates relating to the schedule for the third release. Is that correct?
Correct,
So
yes.
just so you know what you're moving.
Thank you. Thank you, council.
I don't have a strong opinion one way or the other. To me, it would seem that input from staff regarding the workload that this creates with respect to going from an annual to a quarterly reporting system and putting the information on the website, is that a relevant consideration or not really?
It's a defunct.
The requirement would be for the Department of Consumer Affairs
Oh.
to do the reporting, so it would have no impact on CBA staff.
CBA per se.
I'll second the motion.
Thank you on that. So we have a motion and we have a second. Are there any additional comments or discussion from board members? Any comments from the public? Seeing none, I'll now call for the vote.
All right. Kathleen Wright,
Yes.
Deirdre Robinson,
Yes.
Jen Oying.
Yes.
George Family,
Yes.
and Carrie Ann Farrell Hines.
Yes. So the motion carries, and now we can move on to agenda item 3F, which is AB 1190. Wait, no, that was 1190, sorry. SB 27. Ms. Movasaki, please.
SB 27 would require every board within DC to grant a fee waiver for the application and issuance of an initial license to an applicant who is an honorably discharged veteran. This bill does not apply to examination, application, or renewal fees. The April 17th amendments did not make any substantive changes to the bill, only added co-authors to the bill. SB 27 is a 2-year bill, and staff suggests that LC maintain its support position. No action is needed, and I would like to turn it back to the chair.
Thank you. So we took a support position at our March meeting and issued a letter on April the 5th, and unless there is a desire to change our support position on SB 27, no action is needed at this time. I'll open it up for member comments. Seeing none, are there any comments from the public? Seeing none, we'll move on to agenda item 3H, SB 247.
This bill would repeal the requirements for an individual to obtain a license to perform the following activities: fitting or selling hearing aids, locksmithing, barbering or the application of makeup, disposing of cremated human remains, and performing custom upholstery services. SB 247 would also modify the regulation of certain landscapers and tree service contractors to require a license to work on projects valued at $25,000 or more. The bill also repeals a requirement that a licensed private investigator maintain a physical office in California, and that auctioneers and auction companies maintain a bond issued by surety company. This is a 2-year bill, and staff suggests that the LC maintain its opposed position on SB 247. No action is needed, and I would like to turn it back to Madam Chair.
Thank you. Since we've taken a opposed position at our March meeting and issued a letter on April 5th reflecting that position, and there have been no changes in the bill, unless there's a desire to change our position, no action is needed at this time, but I'll open it up for member comments or any comments from the public. Seeing none, we can move on to agenda item 3I. Ms. Movasaki, please.
Thank you. SB 547 is one of 2 omnibus bills that contain language at the request of the CPA and would do the following. First, amend Business and Professions Code Section 5063.3A4 to clarify that during a sale or merger of a practice, a licensee may only disclose client information to the successor licensee or person if the parties enter into a written non-disclosure agreement. Second, amend Business and Professions Code Section 5096.9 to allow the CBA to initiate a Section 100 rulemaking to quickly extend or remove the inoperative dates of the CBA's practice privilege regulations. Staff suggests that the LC maintain its support position on SB 547. No action is needed, and I would like to turn it back to Madam Chair.
Thank you. So we took a support position at our May meeting, and we issued a letter indicating our support on June 22nd. Since there have been, although the bill was amended, it had no effect on the CBA. So unless there is a desire to change our support position on SB 547, no action is needed at this time. Are there any comments from the members of the committee? Any public comments? Seeing none, I'll move on to agenda item 3J, SB 715.
This bill grants the governor the power to remove any member of a DCA board appointed by the governor within DCA for continued neglect of duties, an example of which is the failure to attend board meetings. Staff suggests the LC maintain its support position on SB 715. No action is needed, and I would like to turn it back to Madam Chair.
We took a support position at our May meeting, and the CBA issued a letter indicating that support on June 22nd. So unless there's a desire to change our position on SB 715, no action is needed at this time. I'll invite comments from the committee members. Any comments from the public? Seeing none, we can move on to agenda item 3K.
SB 795 would remove the January 1, 2019 repeal date of the CBA's practice privilege statute, thereby making the CBA's no notice, no fee practice privilege program permanent. Staff recommend the CBA maintain its watch position on SB 795. No action is needed, and I would like to turn it back to Madam Chair.
So since there are no changes on this, and unless there is a desire to change our watch position on SB 795, no action is needed at this time. I'll open it up for comments from members, comments from the public. Seeing none, moving on to agenda item 3L.
SB 800 is the second omnibus bill that contains language at the request of the CBA and would do the following. Amend Business and Professions Code Section 5094D regarding credential evaluation services requirements. Specifically, it would correct a minor inaccuracy in the name of one organization by changing one word from singular to plural and updating the name of another member organization to reflect its current name. Staff suggests that the LC maintain its support position on SB 800. No action is needed, and I would like to turn it back to Madam Chair.
Thank you. We took a support position at our May meeting, and the CBA issued a letter accordingly on June 22nd reflecting our position. So unless there is a desire to change our support position on SB 800, no action is needed at this time. I'll open it up for comments from members of the committee or members of the public. Seeing none, we can now move on to agenda item number 4. That concludes the legislative tracking chart. So, Ms. Movasaki, can you please begin your presentation on item 4A, which is SB 244?
Thank you. Before I begin my presentation, I would like to mention that staff reached out to the author's office to share our analysis of this bill and was informed that the California Newspaper Publishers Association is no longer in opposition. This bill exempts from disclosure under the California Public Records Act, or PRA, records containing sensitive personal information, requires state agencies under the Information Practices Act to collect and use personal information only for the purpose of administering their respective public services and programs, and exempts from the PRA records containing personal information of participants in numerous public services and benefit programs. At the June 2017 monthly DCA Legislative Roundtable, CBA staff was informed by DCA executive staff that this bill would not have a significant impact on the current PRA request process nor the CBA's daily business operations. Staff suggests the LC recommend that the CBA take a watch position on SB 244. This does conclude my presentation, and I would like to turn it back to Madam Chair.
Thank you. So would any member like to make a motion on the reflecting, I'm sorry.
Before you make a motion, may I give
Yes,
some input
Sure.
on this bill?
please.
So I have some real concerns about this bill. And the first concern, if we can look at page 9, well, it actually starts at the bottom of page 8, but it goes primarily to page 9 at the top of the bill. Under current law, the Social Security number is confidential. However, if we are served with a subpoena or a court order that compels us to provide that information, we have to turn it over under state or federal law. The amendment that they're adding is to line 2 of page 9, and it says, "And shall not be disclosed except as required to administer the licensing program, the requirements of this section, or as otherwise required by California law or a state or federal court order." What it doesn't state is required by federal law, because there are federal laws that require agencies to disclose the Social Security number. So my concern is that if we get served with the federal subpoena or a demand by an agency that requires us to comply with federal law, we would be kind of in a catch-22 position of trying to comply with California law and not complying with federal law, and I wouldn't want to place staff in that kind of a position. So I believe it should state, or otherwise required by law, not just California law. That's one issue. The bigger issue for me is page 11, line 28. Under current law, there are 2 methods for obtaining records. One is under the Public Records Act, which Ms. Mogasaki mentioned, but that is for members of the public. So members of the public obtain records through the Public Records Act. That law, however, states that members of the public does not include individuals or agents working for a state, federal, or local agency working within the scope of their duties. So we do not obtain records from other agencies using the Public Records Act. What we use is called the Information Practices Act. This section amends the Information Practices Act. The Information Practices Act is our only authority to share information that's personal with other state, federal, and local law enforcement and regulatory agencies. It also is our authority for disclosing information pursuant to search warrant and subpoena. If you look at the list of permissible exceptions to disclosure of personal information, the list includes search warrant, subpoena, or sharing with other state and local agencies and federal agencies that have statutory duties to obtain or authority to obtain that information, and it's consistent with those duties. So the concern I have is that this statute, proposed statutory change, would change the law in that regard. So if you look at paragraph starting line 28, it says notwithstanding any other law. So whenever you see that language at the beginning of a statute, that means no matter what any other law says, this law controls. That's what that means when they put that at the beginning of the statute. You ignore every other law that says anything to the contrary. So despite what any other law says, sensitive personal information as defined later on, and records containing personal information that are collected by a state agency. Now if you drop down to line 36 to where it's relevant, shall be collected, recorded, or used only for the purpose of assessing eligibility for and administering those public services and programs requested or used by the applicant. So what that means is if we can only use that information if it's requested or used by an applicant for licensure. Now, as you know, that's not the only thing that this board does. We investigate, we enforce the laws under our jurisdiction. So that would narrowly prescribe the use of personal information that's listed in the next page to those instances where we are investigating or evaluating someone's eligibility for licensure. It would not cover people who are currently licensed that we want to investigate. So it doesn't allow us to use the personal information listed on the next page for the purpose of enforcement, investigation, or for sharing that information with another agency that may have a pending investigation for violating their laws, or the district attorney's office, for instance. There's a lot of different situations that we share information to coordinate joint prosecution cases and investigations. So that's my main concern, that this would change the current Information Practices Act law disclosures that permit, not require, permit us to share information under confidentiality agreements with state, local, and federal agencies in order to investigate violations of laws of our jurisdiction and their jurisdictions. And so, okay, go ahead, yes.
I guess my question is, the items that are listed on the top of 12,
Yes, so what this relates to is the personal information. They're redefining what's private, because personal information under the Information Practice Act is private information. So one of the ones that jumped out at me was records of criminal convictions. That is the most public thing that happens to somebody. You're convicted, it's in the Constitution that you have a requirement of a speedy and public trial. It's public. So recharacterizing a criminal conviction as private, sensitive information upends the Constitution. It's not consistent. And it places us in the enviable position of having, for instance, a board of accountancy contact us about a case that's been concluded, that's been fully litigated, has been entered into evidence, a copy of a criminal conviction from a superior court. We would have to say, you can't have that because it's private information. We can't share it with you under this provision. So everything listed here, residential address, date of birth, I don't know if we collect that. We do collect residential address. The board does collect a social security number. Records of convictions, arrests, and adjudications, we collect that. And sometimes income, assets, and debt could be commingled as part of an investigation. The rest of it, I don't recognize as categories of information that we collect. But I think my concern is that the result of the way that it's drafted would impede our everyday enforcement and investigative functions to a point where we wouldn't be able to fulfill the mandate that is before you, which is to protect the public. The comments the DCA exec meant were related to the Public Records Act, which is fine, but that's not what it's amending. It's amending the Information Practices Act. It's the law that lets us share information with other government agencies. And the reason, as you're probably aware of, is because of recent illegal immigration or undocumented immigrant, issues dealing with the federal government and how they're handling immigration and enforcement. I understand that issue, and I understand where this is coming from, but I think it's too broad, and it would, maybe inadvertently, I don't know, impact the way we do business for enforcement cases.
what would be your proposed language?
Well, actually, I have some comments. I wanted to ask whether or not you've been in contact with the author's office and expressed the depth of your concern about this, and the impact that you interpret this as having on the laws. And because I would be uncomfortable with us issuing an opposition position, a letter expressing opposition and expressing that concern without having had some conversations with the author to determine whether or not they have taken this into consideration. The second thing that I'm noting is that there are no other California agencies that have taken a position on this bill, and I think it would be helpful for us to know what other agencies what their thoughts are on this bill before we take a position, because I'm not really comfortable with taking a position without having had a really thorough explanation about what the concerns are, having that information on the record before we put out a letter expressing our position on it.
Okay, so if I could
Yes.
just
Yeah,
answer,
sorry.
could I just answer your question, though? On the first part, my role is to give advice to my clients, and so my opinion is for your use. Only if I'm authorized by you to have that conversation with your staff do I actually have communications with the author's offices. That's not really my role.
Okay.
So,
May I?
Or yes, please. Thank
So
you.
I actually have a suggestion prior to reaching out in consultation with the author's office. Generally, when there's pending legislation that impacts multiple boards within the department, there's a process that we go through, and it's referenced in our analysis, where it's called a legislative roundtable. All of the legislative staff from each of the boards attend those roundtables on, I think it's a monthly basis. And representatives from the Executive Office of the Director of the Department of Consumer Affairs, as well as executive staff from the legal office attend those as well. And in this particular bill, it was analyzed, and in the roundtable, all of the boards received information that the department had analyzed this, as well as the legal department, and they believed there wasn't a significant impact. So I think it would be, I'm certainly not challenging Ms. Shield's analysis, but I think it would be most appropriate for the department executive staff, legal office, and counsel to perhaps vet and understand and gain consensus before we individually as a board reach out to the author's office.
Ms. Wright?
Do we, excuse me, either as DCA or CBA publish our sharing agreements?
sharing, what do you mean sharing agreements?
You mentioned that we have information sharing agreements with, I think you said district council, but various other arms of state government, so to speak.
Correct.
Do we publish or make available to the public information about the information sharing agreements that either DCA or CBA has in place?
No, those investigative agreements or joint prosecution agreements or confidentiality agreements are confidential. So Evidence Code Section 1040 permits state agencies to keep confidential the information that they gain and the agreements that they obtain to maintain those, that confidential status. Only if we were challenged in litigation would those agreements be disclosed. So they've been disclosed when we were in litigation as a basis for substantiating that the information has maintained its confidential status. So part of the problem has been that, that this particular issue was not raised at the roundtable with respect to the Information Practices Act. The question was specific to the Public Records Act, and there was a misunderstanding as to the scope of the question, which I've clarified with my chief counsel. So I will certainly take this back to him, but I've been dealing with the Information Practices Act for 17 years. I know it really well, and I'm familiar with this issue because of other clients who've dealt with concerns raised about how much information is shared with the federal government. And I know what this is intending to do just based upon the draft that I'm reading here and what the legal effect would be. So I just want to make sure that you're aware of it so you can decide what information you'd like to do or what you'd like to do with that information.
Well, I'm no expert on this area of the law either, not by a long shot, but I would say, I am familiar with the IRS sharing agreements, and they do well, I don't know if they disclose all of them because I don't work there, but they tend to disclose where they have information sharing, because with the IRS, that could be very relevant to anything, a lot of different things. And so that's why I asked the question, but let's conclude, so now you have all of our comments, but then.
Well, actually, Ms.
Okay.
Robinson, you raised your hand.
I guess the thing, I'm so glad that you pointed out, counsel, those that concern our ability to be able to share information as it pertains to investigation. On the top of page 12, there's a couple of things that concern me, and that would be line 8, where it pertains to religion, and the other where it pertains to 17, known or suspected political or organizational affiliations. Is it by practice that we would use that information for the purposes of a CBA investigation?
No, I think that the ones that I'm most familiar with in my experience working with boards in the department are residential address, because oftentimes people designate as their address of record a residential
sense.
address. And we would, it's incongruous to say that someone's designated it, but because it's residential, we can't publish it as our address of record for that CPA. That's a problem. But religion, I mean, birth date, I don't think, do we collect birth date? Okay, so birth date is collected. Religion, no. Marital status, no. Immigration status, no. Social security number or tax ID number, yes. Records of criminal, juvenile arrest convictions or adjudications, yes. Status as a victim of a crime, no. Known or political or organizational affiliations, no. Status as a recipient of public services, no. Health information, not that I'm aware of. And income, assets, and debt can sometimes come up as part of an investigation relative to dishonesty charges sometimes. But that's not typical that we collect that type of information. Credit information, again, I haven't seen that, but staff could speak to that. But the one that is, to me, the most problematic from an investigative perspective is records of criminal convictions.
I agree
mean,
with
that
you.
is so public, and that is some part of our transparency to the public, that we have information that we've used in our cases to prosecute, different people, that we disclose on the internet. I mean, would we be able to still do that anymore? I don't know.
So
So-
I asked that question to proceed to the next question, if I may.
Yes.
And that is, would it be appropriate for us to ask or line out those items that are not needed by CBA? Because it seems to me if we're going to oppose or not oppose or approve, that we would take out those areas of this bill that are not necessary for the exchange of information as we use it.
My discomfort with issuing a letter requesting a change to the bill is that the concerns that have been raised by council are fairly significant concerns, and there is some tension between the recommendations that council is making to us and the executive staff's and the staff's recommendations that have been made. Staff is reporting to us that they have had extensive conversations about this and that there is not a concern, and now we have council suggesting that there are some concerns. So because there is this tension, and there are some things that sound like they may have been raised after the meeting that staff had that staff had regarding this bill, my recommendation, would be potentially that we ask staff to go back to this DCA legislative roundtable, where I'm sure that they have some ability to coordinate with the authors about the bill or communicate with the authors about the bill, allow staff to express these additional concerns, and then report back to us what the findings are of that DCA legislative roundtable, because we're not the only licensing agency that could potentially have these kinds of concerns. And so if other agencies raise this as a concern, then that could be some helpful for us in determining what our position is. But if the collective DCA is not concerned about the impact of this bill, taking into consideration even some grave concerns that council may have, it can give us additional guidance as to what we would like to do. So,
I have no problems, and I'm not opposing that nor making a proposal.
okay.
It's more for information, and I pose that as a question. Because it seems to me that if we're going to be talking about going to the round table or what we're going to consider, what I'm expressing is my concern about what they consider to be personal information. If it is not beneficial to CBA, I'm confused as to why we're not highlighting exactly what it is that we need and kind of crossing out that information that we don't perceive to be pertinent. That's a question, I guess, in some way.
Well, I think this issue that council has raised on page 11 about the potential change to the Information Practices Act, I think that's an area that really requires some clarification for us as to the extent to which this bill actually or is intended to change the Information Practices Act. And it sounds like that may not have been discussed as extensively at the DCA Legislative Roundtable specifically. So I would like to recommend that staff take that back to that larger body's discussion. And I would assume that in the context of having that conversation, this issue would come up as to what records would be included, and the extent to which it would allow an opportunity to raise the concern about whether or not this act would preclude us from having access to those criminal records, and also allow us to express, our staff to express how that could impede our ability to perform our investigative function as a body.
Thank you for taking that into
So-
consideration.
Is that a motion?
No, well, it doesn't require a motion, it's just an instruction to the staff that they listen to the minutes of this, that they review the minutes of this discussion, and then take that back for further clarification, and then report back to us, I would assume, at the September meeting as to what the findings are. And at that time, we also would be able to have counsel to give additional recommendations as to what the report, the impact that the report would have, so.
I make a motion
Oh.
that, what you just said. I make
I think I hear you
that we report
moving.
back after going to the round table and clarifying the discussion, the robust discussion that we had here, those points and those elements, bringing it back to the September meeting, and then we would make a decision at that time as to what the position would be. That would be my motion.
Thank you, Ms. Robinson.
You're so welcome.
I second.
So we have a motion and a second. Are there any additional comments from board members? Any additional comments from the public? Hearing and seeing none, I will now call for the vote.
Okay, Carrie Ann Farrell Hines.
Yes.
George Familet,
Yes.
Jin Oh Yang.
Yes.
Deidre Robinson.
Yes.
And Kathleen Wright.
Yes.
Thank you very much, Ms. Movasaki. I think we are ready to move on to agenda item number 5. So agenda item number 5 is an update on legislation the California Board of Accountancy is monitoring. This is a written report only. Are there any member comments on this item? Any comments from the public? Hearing and seeing none, the next agenda item is number 6, which is discussion about legislative items for future meetings. Ms. Movasaki?
Nothing to report of this.
Thank you.
I don't, again.
Ms. Wright?
Thank you. If this is if I'm bringing this up in the wrong place and on the agenda, just please let me know and I'll defer it to wherever you tell me that it should go. But I have a question for staff regarding the legislative process, and which is, there are hundreds and hundreds of bills introduced into the legislature each and every year. How do we identify which bills have relevance for CBA?
So we track each of the bills based on keywords so that they come to our attention, and then really that's a consultation between staff and management. We analyze those bills that have some relevance, make a determination whether or not it's appropriate for this board, generally focus more on our consumer protection responsibilities, and then those items come forward. So it's really a staff function along with management.
Okay. The only reason I bring it up is there was a bill that came up and actually was signed by the governor that the AICPA raised issues about regarding boards of accountancy, and I did not recall that we had discussed it here. It was AB 102, and it deals with the establishment of the Office of Tax Appeals, and the question that is being asked is whether or not CPAs who are practicing in California with only a practice privilege have the authority to represent clients before this new form. Board of Equalization is gone. The SBE is no more, not for income tax appeals. And now the Office of Tax Appeals, a wholly new department, that one is not within DCA, but anyway, there were 2 that were established, but that's a detail. The question is, and I'm repeating myself, whether or not CPAs are allowed to practice in that form. Question, can CPAs who are practicing here with a practice privilege practice in this forum?
And that was a bill actually that we did review, and I made an assessment that it was not appropriate to bring before this board, and so I would be happy to discuss that at some later date.
Or
Could
the
we-
mobility group, I don't know. If the mobility group could answer the question, I don't know.
Yeah.
So that's probably a topic not for discussion today. Certainly, it's not on the agenda, and would probably be most appropriate for me to consult directly with the board president on.
Okay.
Then could I just ask, since Ms. Wright raised it, if we could make that an agenda, a report on that, a follow-up on that, on an agenda item for the next meeting on AB 102? The, presentation of what the bill was and, what impact or it has or doesn't have on the accountancy practice.
Again, I would encourage that perhaps that's something I can directly consult first with the board president, and then a determination can be made whether it's appropriate to bring that forward.
All right, thank you. Is that-
Sure,
is that
that's fine.
fine?
I
Okay.
just wanted to ask, that's fine.
Thank you, Ms. Wright. Are there any additional questions from, Ms. Movasaki, did I ask if you said you didn't have anything additional. Any additional member comments? Any additional comments from the public? Hearing and seeing none, we're on to agenda item number 8. No, number 7 or number 8? Let's see. Because I don't know. Yes, so number 7 is public comments. Are there any additional public comments? Seeing none, we are adjourned. Thank you very much.